Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. If you've ever had a question about your employment law rights, then you've come to the right place. Welcome to Ask a Lawyer. I'm your host, Dana Levinson. Every week, our experts discuss your employment rights in Canada. Joining us is employment lawyer John Pincus, partner at employmentlawyer.ca. Before we get to today's questions and phone calls, John, why don't you tell us why it's important that every Canadian know their employment law rights and perhaps talk about a case that you had from this past week?
Well, it's really good to be back, Dana, and especially because every week is another reminder that employment law myths surround us. A lot of times people are taken advantage of, sometimes because the employer is unscrupulous, trying to get away with something they're not supposed to be. But I actually find most of the time it's because, like employees, most employers don't know the law either. It's more often ignorance than malevolence. That's what I find in 90% of these cases. And when something goes wrong, whether the employer is trying to do it wrong or simply doesn't know what to do in order to follow the law, it can be extremely intimidating. It can be extremely scary for some people, especially if you've been in a place for a long time, especially if it looks like there's no way out. And this example that I want to talk about today is a perfect testament to that. We had a case recently where an individual was employed for a long period of time and had gone on disability. And at the 2-year mark, the disability insurer said, well, you know what? You don't meet the definition of disability under the policy in order to continue on long-term disability benefits. So we are going to cut you off. We're going to cut you off, and we think you should go back to work. The employer is copied on this and says, oh, I guess you're not sick anymore, so you should come back to work. Now, the employee had a doctor's note, which the employer had, that said that actually this was not a situation where he'd go back to work. He had significant psychological and physical ailments that would really hinder any realistic return back to work. He's told to go back to work. He goes back to work anyway, even though he knows he shouldn't be doing it under his doctor's advice. And of course, the return to work fails completely. The employer doesn't really provide any accommodations, really shouldn't have been at work in the first place. So he doesn't make it. He doesn't finish the return to work plan. And he goes home and he's told that he's abandoned his employment and he's not given any severance. Now, there are so many reasons that this situation should not have happened, but actually it happens all the time. Let's start with the biggest reason why this shouldn't happen. The biggest reason why this shouldn't happen is because your rights under a disability contract are not the same as your rights vis-a-vis your employer. So you may not be entitled to receive disability benefits under the disability definition under the policy, although we know many times insurers are wrong about that too. But even leaving that aside, your rights in your employment depend on whether you can medically continue to work. And if your doctor is saying this person cannot be working, that is what prevails. And the employer should have spoken with the doctor, should have engaged with the doctor, didn't do that here. Secondly, even if you are unable to work forever, for the foreseeable future, due to a disability, you are still entitled to some severance. It's not going to be your full entitlements, but you're still entitled to your minimum entitlements. But the employer has to show that you couldn't continue to work or that it would have been undue hardship for the employer to accommodate you. That didn't happen here. The employer is guilty of a human rights breach. They're guilty of a wrongful dismissal. They're going to owe significant severance, and they're going to owe human rights damages. What a mess.
Wow, what a case. That's a significant case. Thank you for sharing that with us. If you want to get in touch with John and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. Let's kick things off by taking our first call. John, these calls come to us through your show, which is through Ontario and across Canada, where you take questions live from listeners every week. So let's listen in.
45 years with the same company. I'm a bank teller, and those jobs are disappearing because of digitalization of people's banking services. I'm over 60, and I have the feeling that I'm kind of going to be going through that. I had asked upper management if they would package out an employee, and they said, well, we don't offer packages.
Interesting.
Right. So let's make sure we're interpreting properly what the employer is saying here. It sounds like what the employer is saying is they don't offer voluntary packages, right? Some employers will say, well, once you reach a certain point or at a certain point in the company's evolution or restructuring, you can volunteer for a severance package, in which case you're going to be entitled to severance if they terminate your employment then. But here they're not going to do that. They're going to say, we're going to keep you around. Well, in that case, you have to wait until the employer actually makes the decision to terminate your employment. Because unless you fall into a situation where it's a constructive dismissal, and we don't see any of that here based on what's been described, if she leaves, it's going to be a resignation. So very important. Secondly, if and when her employment is terminated, she should know that although some things that you may find online say, well, you're differently entitled if you are a federally regulated employee, not the case when it comes to your full entitlements. For her full entitlements, she actually has the exact same entitlements to severance as everyone else, and after that many years, it could be very significant. So let's take a look at the Pocket Employment Lawyer, the severance pay calculator, and we'll see just how much this person could be entitled to in these circumstances. So you see she's 64 years old, she's been employed for 45 years, and she's a bank teller earning $45,000 a year. And we see this as someone who could be entitled to up to 2 years' pay, not just because of her length of employment, but also because, as she mentioned, this is a line of work that is significantly decreasing. And the law takes that into account. The law says, well, if you're in a job that's disappearing from the market, you're going to need longer to find a new job, and you're going to need a longer severance package as a result.
Okay. Let's take a quick break. And when we come back, employment lawyer John Pincus from employmentlawyer.ca may surprise you with facts about your termination rights you likely didn't know about. Stay with us.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. Employment lawyer John Pincus from employmentlawyer.ca is answering questions about your workplace rights. If you want to get in touch with John and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We have more calls and emails coming up, but John, before we get into today's topic, which is severance rules, let's clear the air on this one. Okay, number one, severance rules aren't different if you've only worked somewhere for a short period of time.
That's right. We still look at the same factors. We look at your age, we look at your position, and yes, we do look at your length of service, but just because you've been somewhere a short period of time does not mean that you get no severance. It doesn't mean that you get a small fraction of your severance. The court looks at everything in context. The law looks at everything in context. So maybe you had a disability. Maybe you had a non-competition clause saying you couldn't work for a year. Well, that's not going to be fair if we just look at you as just a short-term employee. Maybe you had a very high-level role. So people who've been employed for 6 months, 8 months, 10 months, a year, 2 years, they can still be entitled to a significant amount of severance that often seems to be disproportionate with their length of service because the law recognizes that even those with a short period of service are still going to need time to find a new job.
Okay, our next one. Severance rules aren't different if you work in construction or the trades.
That's right. Now, this is an interesting one because under the Employment Standards Act, certain construction jobs don't get their minimum entitlements, but you are still entitled to your full entitlements. So for many people, it is a distinction without a difference. Now, the one caveat here is that if you are unionized, well, then I have to say that one sentence that fortunately I don't have to say very often, but I hate saying it, which is, I can't help you. If you are unionized, I cannot help you. But if you are non-unionized in a construction position and you are let go, you still have rights.
Okay, good to know. Third on our list of times when severance rules aren't different. You are a part-time employee.
Right. Well, the rules for part-time employees are actually exactly the same as they are for everyone else. We look at your age, your position, your length of service, any factors that may elongate your job search. What's the difference? Well, you're making a part-time income, so your severance is going to be based on your part-time income. That's it. Everything else is the same.
So you still get severance.
You still get your severance.
Okay. We're talking about the times that severance rules aren't different when you are misclassified as an independent contractor.
Boy, this is a very, very common one, Dana, of course. We get lots of these coming in all the time. People who are paid through a contract, they remit HST, but in fact, they are an employee. They have to go to work every day. They report to one employer. They may get their expenses reimbursed by the employer. They effectively have a 9-to-5 job, or maybe not a 9-to-5 job, but a job where they're working for one person, and they're just treated on paper as a contractor. Well, the law doesn't care about that. The law cares about who are you in business for? Are you in business for yourself, or are you in business for the company? If you're in business for yourself, well, then that's just a client. But if you're in business for them, then that is your employer, and you're going to be entitled to severance just like everyone else. And the great thing is, on Pocket Employment Lawyer, we have a tool where you can find out whether you might have been misclassified, and then a severance pay calculator to see how much you may be entitled to.
Okay, terrific. Last on our list of times when severance rules aren't different. If you work for a company with a payroll under $2.5 million.
Right, this is a big one. Huge, huge myth here, that if your payroll is under $2.5 million, you don't have to pay severance. A lot of employers genuinely believe this, but it's not true. That is only for the purposes of minimum entitlements under the Employment Standards Act. Certain minimum entitlements, that payroll matters. But for your full entitlements, the entitlements that we're talking about in the severance pay calculator and on this show, that makes absolutely no difference whatsoever. So for all intents and purposes, your full entitlements are the same. Big company, small company, doesn't matter.
Okay, let's listen to another phone call from one of your live radio shows. Take a listen.
I've been working for a company for a while. When I was hired, we came to a few agreements, for example, taking a vehicle home and what my start time would be and when I would start to get paid from, right? My old boss, he's been fired, so now the new one is changing some of those arrangements, but obviously they're not changing them to my benefit, right? Do I have to accept that? Is there something else I can do?
He can do?
There may be, but this is the kind of thing where I wouldn't want to give an answer right now. What I can tell you is the things that we would consider. We consider if this is something that he historically had, if it's something that is going to change his compensation, if it's going to significantly impact the time he's to spend at work, the expenses he has, that could be a constructive dismissal. And he is right to ask about it because you have to act quickly, because if you don't act quickly, guess what? That's the new deal. That's your new employment, and then you can't do anything about it. So you do have to act quickly. Maybe wait a week. I wouldn't wait much longer than that. Speak to an employment lawyer. Once you understand what these changes are, then you have to make a choice. Are you going to accept it and continue in your employment, or are you going to object to it and treat it as a constructive dismissal? You shouldn't do that too early, because if you do it before you speak to an employment lawyer, it could be resignation, but you also can't do it too late. So, tricky situation, speak to an employment lawyer right away. Find out your best option.
Okay, let's take a short break. And when we come back, a look at what happens if you're fired due to a health issue and responding to a layoff request that carries the promise of a recall. More to come right here on Ask a Lawyer.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. John Pincus from employmentlawyer.ca is taking questions about your workplace rights. If you want to get in touch with John and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We have lots more to get to, including this call that came into your radio show recently. Take a listen.
I was recently dismissed from my job. I'm in construction a year. I'm 40. I don't know what my rights are. I haven't seen the record of employment, so I don't know what it says as to why they dismissed me. I've been missing a lot of work due to a illness, and they know this, and it's been documented. I'm thinking that that's why they've opted to give me my walking papers.
Wow.
Right. So let's first start with one myth that we often hear in these situations, which is that a construction employee is not entitled to severance. They are, in fact, entitled to severance, and we look at the same factors. The other issue is, now the record of employment is for the purpose of employment insurance, often does not say the reasons for dismissal, but still has to be right. And so if they say something like, you quit when actually you were terminated, that's a problem. Another reason why you want to make sure as soon as possible, if you don't get a termination letter, you get some kind of written confirmation of your termination. But even someone with a short tenure, someone working in construction, is still going to be entitled to severance. And if we look at the severance pay calculator, we look at someone with this kind of tenure, 1 year, working in construction, 40 years old, they're still going to be entitled to potentially 3 months of their pay. That could be very significant for someone looking for a job and wanting to bridge that gap. So we have a severance issue, we have potentially a human rights issue. The first thing to do, get it confirmed in writing, and once that termination is confirmed in writing, either through the record of employment or otherwise, that's the time to call an employment lawyer and get you what you're owed.
Okay, time for another question. This one from one of your live streams on Facebook and YouTube, which people can find by going to @stlawyers.ca. I've been working as a manager for 20 years. Now they're telling me that I'll be laid off, but only temporarily. They will call me back later this year, which I'm told is allowable under our laws. Is that true?
Well, yes and no. Employment Standards Act says yes, but you personally have to have agreed to that. If you haven't agreed to that, forget about 13 weeks or 35 weeks within a year, which is what your employer is going to be saying. That very well could be a constructive dismissal. And if it is a constructive dismissal, you are going to be owed your severance just like everyone else. The starting proposition for everyone is that you don't have to accept layoffs unless you agree to them. If you haven't agreed to that in writing, you could have a case for constructive dismissal, and you should speak with a lawyer fast.
Okay, let's take a quick pause. And when we return with John Pincus, partner at employmentlawyer.ca, can your employer fire you for the wrong reason? And taking time off work due to COVID, those issues and more coming up right here on Ask a Lawyer.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. John Pincus from employmentlawyer.ca is answering your employment law questions. You can connect with his team by calling 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. Let's take a look at another situation that your firm has come across. A new VP joined the company. Just 2 weeks later, I was fired. She claimed that I didn't align with the company's vision, but I have proof that she just didn't like me. I was given 11 weeks after 13 years. Can they just fire me for the wrong reason like that? What do you think?
Well, based on what's described here, I wouldn't say that's legally the wrong reason, because the right reason is almost any reason they want. Now, that doesn't mean that they can fire you in all circumstances. So, for example, if they fire you in reprisal for you enforcing your rights under the Employment Standards Act or Occupational Health and Safety, that's a big no-no. They can't do it because you enforcing your rights under the Human Rights Code. They can't do it because of a reason under the Human Rights Code. So they can't do it because you took a medical leave or a parental leave. They cannot do it for anything that is discriminating against you, even if they have other reasons as well. But they can do it because they don't like you. When we're talking about a wrongful dismissal, we're typically not talking about an employer who fired you without a reason. We're talking about an employer who didn't give you the proper severance. Unless they've terminated for just cause, or they've discriminated against you, or it's motivated by some reprisal that's illegal under the Occupational Health or Employment Standards Act, then typically they are actually allowed to do that. They just have to pay the proper severance. That's the question. That's why we have the severance pay calculator.
Right, so you can get fired if your boss doesn't like you.
You can.
Okay, it's good to know. Let's take a look at another scenario that your team has handled recently. I woke up with extreme COVID-19 symptoms yesterday and tested positive later that morning. When I asked my boss for time off work, he said I needed to produce a doctor's note to prove my condition or he would fire me. What are my rights?
The perpetually topical COVID-19. So this is an interesting topic because right now we have a law on the books that until the end of March of 2023, you do not have to produce a doctor's note and you are entitled to 3 paid days off. So right now, that would be clearly a violation of that. Normally you do have to provide a doctor's note, but not in these circumstances. Once those 3 days have passed, if you have a doctor's note, you are still entitled to remain on a medical leave so long as your doctor substantiates that. And if you are fired because of it, it's going to be a human rights violation. But right now, it's a human rights violation and a breach of the Employment Standards Act. So this is someone who should definitely be giving a lawyer a call.
So what happens if you do have COVID-19 and you just feel lousy after a week? Maybe it's 7 days, you're going on to even 10 days, you have that horrible virus feeling, and you don't have a doctor's note, and you don't want to go to work.
Well, I would tell your employer in writing, and then I would think of maybe using telehealth or some kind of doctor service that's either online or on the phone to get something in writing so you can submit to your doctor. But employers, if you're watching, if your employee is telling you that they are sick, take that seriously.
Right, for everybody. Right.
For everybody.
For everybody. Thanks, John. It's wonderful having you here again today. You can catch legal experts from employmentlawyer.ca on Ask a Lawyer every Wednesday on CP24. For more information on this show and employmentlawyer.ca, visit cp24.com/askalawyer. Next week, we'll take a look at some of the things that employers are not allowed to do in the workplace. Thanks for watching.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.